For everyone, good morning to everyone who's with us this morning. This webinar is a part of a series of real-time solutions that is brought to you by the Apple Valley, Burnsville, Hastings, Lakeville, and River Heights Chambers of Commerce. The goal of these webinars is to address business concerns and questions as we continue to do business during the pandemic. My name is Krista Jeck, and I am the president of the Lakeville Area Chamber of Commerce. And just some housekeeping items this morning, just a reminder that all participants are muted. So please use the Q&A feature to ask questions, and we'll get to as many as we can following the presentation. And just a reminder that this webinar is being recorded and you will be able to see it on all of our partner websites. And so we are here today this morning to hear from Matt Scopp. He is a litigation attorney for Doherty, Melinda, Solfest, Hills, and Bauer, PA. And we've been fortunate to have Matt on a couple of these webinars already. And what he is going to cover this morning is a common question we are getting right now. So many of you are wondering, as we are starting to open and continue to do business during this pandemic, what is your business liability during this, and how do we kind of protect ourselves as businesses? So Matt, thank you so much for being here this morning, for talking through. I know you've got a lot to cover. So I am going to, I'm going to share my screen here and get ready to take it away. I'll turn it over to you, Matt.
All right, thank you. So we're going to cover a few different topics, and what I wanted to start off with first is just kind of an overview. You can go to the next slide.
Okay.
So a lot of businesses are concerned with limiting their liability in this time. You can never eliminate liability completely, or the risk of potential exposure to liability, but you can do a lot of things to limit it. And so I'm going to go through a few different categories. We're going to focus on employees, customers, government, and then how. And kind of the overarching theme here is be reasonable and be compliant. So you can go to the next slide. So limiting your liability, be reasonable and be compliant. One of the things that I think is important to think about here is different people have different, political or different views about COVID-19. And what's important in the long-term outlook is don't be the outlier. Don't be the business that didn't care, didn't follow the rules, didn't follow the directions of the government, the CDC. Let the science be the sort of the touchstone and the framework for what you're doing and how you're doing it with regard to your business. I would also say continually reevaluate. Things are changing constantly, as I'm sure everyone has seen. So from week 1 to week 2 to week 10, things have changed, and you need to reevaluate what the data says and sort of the conventional wisdom and what that's telling businesses to do. Be reasonable. One of the things we're going to talk about near the end is the tort of negligence. One of the elements of that looks at what a reasonable person would do under the circumstances. Would a reasonable person drive down Cedar Avenue at 90 miles an hour through a crosswalk and a red light? No, the answer is no. But that is also a question you can ask yourself when it comes to running your business and how you treat your employees, and how you treat your customers. Also, be compliant. You can't be compliant if you don't know what the rules are. So you need to stay informed of the law so you can follow it. Use your payroll provider, your insurance broker, your accountant, and your lawyer to find best practices and to try to follow those. Next slide. So with regard to employees, again, nothing can eliminate risk. Sometimes crazy people find crazy lawyers, and those lawyers file lawsuits. So I can't eliminate all risk if I'm a business owner, but I can certainly do a lot to limit it. I would say one of the things that you could do, it's a huge favor to yourself, to your business, is go to this link and read this document. I'd read it once a week for the next 4 weeks. This educate yourself bullet. It's at the Department of Labor and Industry. This will be available. It's a PDF, and it goes through all kinds of helpful questions that employers ask about how they treat their employees, what they should do, what they cannot do, what the employees are allowed to do, and what the employer cannot retaliate against the employee for doing. So it's something that I wouldn't want to sort of summarize, cover the whole thing here, but I would definitely recommend that everyone read that information sheet. Also stay up to date. The Centers for Disease Control and Prevention and the Minnesota Department of Health are constantly putting out new information. And so you can sign up for newsletters that are available at this other link on this stay up to date bullet. Another just a helpful hint and a tool for employers and businesses is that when you terminate someone's employment, which you can do in this time, that you pay a severance. It's not a requirement. Your employees are probably at-will employees. They can leave their jobs and they can be fired at will. But if you pay a severance, the severance is always tied to a release. And that release is very robust. It has lots of elements and components that need to comply with state and federal law, including how long an employee has to consider the release. But if you have a good, solid release, you at least have really limited the employee's ability to create risk for your business going forward. Next slide. So as you are probably aware, you need to have, most businesses need to have a plan. So develop a COVID-19 preparedness plan. One size does not fit all. There are obviously differences in the risk associated with certain business types. So, thoughtfully prepare one for your business. Executive Order 2056 is kind of the last information that we have on the reopening of businesses. And so in that order, there is a link that says it is a link to a sample plan. It's not really a link to a sample plan. It's sort of a link to another page where you get to sort of search around to try to find the sample plan. But this is a link to the sample plan. And there's also industry guidance coming out pretty regularly for the industry that you may be in. So if you click on the industry guidance link, which you can't do by Zoom, but you could do when you get this PowerPoint presentation, you'll see that all the industries that are currently available are listed, but then they also have a few that are in the pipeline and coming out. And that is very detailed industry guidance. What I would say about being reasonable, coming back to that point, is that when you follow industry guidance that's put out by the state, it's very unlikely that someone's going to, in the future, a year from now or 2 years from now, be able to come back and say, you were following the state's guidance on the Department of Labor or website or the DEED website, and that was unreasonable. Most likely it's going to be found to be reasonable, and so if you follow that, you're going to be in pretty good company. If you need help with your plan, Minnesota OSHA will assist, or they say they will assist. As with many of these government agencies, they're very heavily taxed right now, from unemployment to OSHA. So be patient. There are phone numbers and there's an email to use if you want to call them or email them. Next slide. In the workplace, over-communication is key in a crisis. So your employees are going to be asking questions. You've already been through this for many months. You need to keep the concerns of your staff and your customers at the forefront and stick with the facts. The EEOC does allow you to test. So you can test a customer. You can test an employee. That's not the typical protocol. It's unique to this pandemic. You do need to keep it confidential. You can refuse service to someone who tests, has a temperature. I think the conventional wisdom is 100.4, but I'm not a doctor, so you may want to check other places for that. Ask about the symptoms. You can certainly ask about the employee's symptoms. And if the employee has symptoms, you can send them home. You need to keep any records confidential. And you can also do daily compliance checks. Either you can do those as an employer, or you can cause the employee to have to fill out a form that says, they don't have a cough, they don't have a fever, and that they don't have any symptoms of COVID-19. If someone does get sick in the workplace, you're kind of in a different world then. You need to really be careful in how you handle that. You need to make sure that you warn other employees that they have been exposed. Don't tell them who exposed them. And the reality is the Minnesota Department of Health will probably also be in contact with those employees who have been exposed. Next one. Again, just a reminder, HIPAA does not apply to all employers. HIPAA applies to healthcare providers. But employers of 15 or more are governed by the Americans with Disabilities Act. So that does have a protection component to it for employee data. And you can't go around telling their coworkers when someone is sick. Smaller employers are also governed by state law as opposed to federal law under the Minnesota Human Rights Act. So make sure you understand which law applies to you, and don't disclose employee illness data unless it's without the employee's identifying information, so that you can protect other employees. Employees should be who are ill should be isolated at home. I'm sure many of you have seen and read about the Minnesota or the Family First Coronavirus Response Act. I'm not going to cover that here, but that has a lot to do with the benefits an employee is entitled to during the 14 days that they're sick, or other options, staying at home if they're caring for someone else, or home with children who are home from school. This is not a time to demand a doctor's note or strict compliance with those kinds of requirements that are usually required of an employee who stays home. Doctors are not working normal hours. Some family practice physicians are on odd rotations. They may not be available to provide a note. So now is not the time you want an employee in the office for 2 days wondering whether they're ill. Next slide. We do have time. So limiting liability to customers. So we're kind of shifting a little bit from employees to customers. I think it's very unlikely that anyone is going to be sued by a customer or by an employee because COVID-19 has caused them to become ill or to die. I think that's unlikely. I think it's more likely that employees will file suits because their rights have been violated in some way in connection with the laws that have been passed to help us navigate the situation. But even that said, and we're going to get to this in a little bit, when the harm is significant, like a death, the likelihood of some risk to the employer or the business is higher. It's just naturally higher. With regard to customers, I would say implement the plan that you have, the coronavirus COVID-19 preparedness plan, and have a plan to keep customers safe. It is required for most businesses under Executive Order 2056. And enforce the policies. Don't let your plan slide. Regularly communicate the importance of the plan to your employees, because they're the ones that are going to be implementing the plan for your business and protecting customers. So if you say you're going to sanitize something, whether it's a door handle or a conference room table or a chair, actually do it and make sure that you're following up with your employees and encouraging them to comply. Use clear signage for customers so that they know where to go, which way to walk, which path to follow. Grocery stores are doing this. Those things are important to keep customers safe, and it's a way that you can help customers understand how you are protecting their health. Document your plan and your compliance. So this is important, and it's not something that people think about now. Right now, you're thinking about implementing the plan. What is the plan? How do we follow the plan? But a year from now, 2 years from now, 3 years from now, when the lawsuit happens, you want to be able to go back to a notebook, a binder, or something that's been basically frozen in time that shows what you did, how you did it, how you complied, because that person who files the lawsuit is not going to have one of those binders. And if you have one to show what you did and how you did it, you're going to be in a better position to document that what you did was reasonable. And we'll get to how that affects the negligence towards the end here. Some businesses are obviously high risk, and they need to be aware of that risk and take special precautions to prevent the high risk behaviors. I think of dentistry. It's one of the, probably the most, one of the riskier businesses that has reopened because a lot of the dental procedures cause aspiration, coughing. When people put things in your mouth, you just tend to not want them there. And so dentistry has had to completely shift gears in how it deals with PPE. And there are also some other unique risks to other businesses. Obviously, restaurants and salons and gyms have found themselves in a really difficult position. Next slide. I wanted to have a slide about the mask because I know it's been coming up a lot lately. And this one is, text is kind of small, but you know, I think you're on fairly solid ground to say that if someone doesn't wear a mask, and this is a decision each business needs to make. I'm not going to say that a business has to require mask wearing. I don't think it does. But if you do, I think you can refuse service to someone who doesn't wear a mask in your business. I know Costco is doing that, so you'd be in good company. So obviously we already have done that with shoes and shirts. If you don't have a shoe, you don't have shoes, you don't have a shirt, you can't come in. So again, you're in good company. The governor, the CDC, a lot of recommendations encourage mask wearing. This is more of a novelty, but it is a reality. It is a law that mask wearing is still a crime in Minnesota. Technically, I think, and actually, it's on the books. So the law actually reads: a person whose identity is concealed by the person in a public place by means of a robe, mask, or other disguise, unless based on religious beliefs or incidental to amusement, entertainment, protection from weather, or medical treatment, is guilty of a misdemeanor. So it's a misdemeanor, up to $1,000 fine. Crazy. And this is not medical treatment. Wearing a mask is, in a number of different contexts, has been specifically not defined as a medical treatment when it's used the way we are using it. So we're all criminals. The law was originally designed to target the Ku Klux Klan, and so for that had valid justifications. But now we're all wearing masks, or many of us are, and even the aiding and abetting statute makes the governor and the mayor of Minneapolis now liable criminally for encouraging us all to wear masks. So this is all kind of foolish, but it is a reality that this is a law on the books in Minnesota. I don't think it should impact significantly your decision whether your business should require masks or not, because it is not being enforced. And obviously, if the governor says we should wear masks and a prosecutor goes out and prosecutes someone for wearing one, that's probably going to make a headline and it's probably going to get dismissed. So, but the crazy reality is that if in Minneapolis you wear a mask, it's $1,000, up to $1,000 fine under state law. But if you don't wear a mask, it's $1,000 fine under the Minneapolis ordinance. That's obviously not the way the law is supposed to work, but the legislature is probably not going to change it because, as you've seen, maybe this is a partisan issue, and so I don't see that being modified. But it sure is not getting a lot of press. I will say that. Next slide. So could I be sued? OSHA talks about employee safety, and specifically an employer has a duty to furnish to each of his employees employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to his employees. And that's a quote from OSHA. So exercise good judgment, put the safety and health of your employees and customers first, and work backward from there. That's just a common sense way to think about your business and the safe environment you're providing. Get insurance against the risk. Now is a good time to reevaluate risk. There may be options out there for insurance. I'm not an insurance broker. I do know that in this environment, there are a lot of people that don't have insurance against the things they thought they had insurance for. And so now is a good time to think about why you don't have it and whether you should buy it if this ever happens again. Next slide. So could I be sued? This is a quote from an article I read online, and it just reads as follows. These are claims that an employee or as a customer at a business, whether grocery stores or movie theaters, you did not take appropriate actions to safeguard me from the coronavirus, and I've had injury that flowed from that. And your basic negligence type of claim is a big area of concern. So it's happening, it's out there. I wanted to look briefly at what is a negligence claim. So if you get sued, and litigation is what I do, the lawsuit starts with a complaint. And the complaint sets forth facts at the beginning, and then it goes into the counts. And one of those counts in a lawsuit like this would be for negligence. And in order to plead a count of negligence, you have to have the elements all recited in the complaint. And these elements are duty. You owed a duty of care to your employee or your customer. And then here, what would a reasonable business do? What would the reasonable business do in under those circumstances? That would be your duty. And then a breach of the duty, your business failed to meet that duty. Cause and fact, so but for the failure to meet the duty, the employee or customer would not have been injured. And then proximate cause, your failure and not something else caused the injury. And then finally, damages. The employee or customer has actually been injured and suffered some loss. So next slide. This is going to be a focused fight in the future. It's not going to be, you're not going to have much control over damages because that is going to be what it is. The person is going to be ill, they're going to have medical expenses, and in worst case scenarios, they're going to die. And so you can't control that aspect of things, but what you can control is what you do right now. And so you can impact the breach element discussion and the causation discussion by what you do right now. And what I would say is document. Like I said, have this binder, have this documentation that you're preparing about what you did and how you did it. Have a plan, keep good records, and follow your plan. And if someone does get sick in your business, you'll have an argument that you did not breach your duty. So you had a plan, you executed the plan, and the duty that you had to the customer was satisfied, and you met your obligation. There is no strict liability. There is no automatic, you are liable if someone walks into your business and they get COVID inside your business, if you were following a reasonable plan at the time. So follow the plan, and you give yourself better arguments in the future. The causation argument, COVID-19 is very difficult to track. It's especially difficult now with community spread. It's going to become more trackable. And in fact, it sounds like it's one of the clear advances is going to be when they have all of these people tracking every contact that an infected person has had, so that they can figure out who they were in contact with. When it gets to that level of specificity, there may be ways to track COVID to a specific business, and for that, it's going to be relying on public government officials who track down where people were. But again, it comes back to the breach discussion and the impact you can have on whether you were reasonable by following your plan. The damages argument, again, where loss of life occurs, there is just a very significant harm that results. Now, whether that harm is someone's fault is a question for a different time, but when the harm is significant, the tendency to want to get revenge, I wouldn't say revenge, but to be made whole is greater than if the harm is low. Next slide. I think this is the last slide, and I wanted to just say one thing about limited liability entities. Almost all of you probably have an LLC or a corporation, or an LLP or an LP, and there are just a variety of different limited liability entities out there. And that means that your investment into that entity, if it's $100,000, that's what you put at risk. You don't put your $1 million house at risk. You don't put your cars at risk. You put that $100,000 into the entity, and you could lose it. But if you lose it, that's how the entity is supposed to work. But there's also an argument that's made sometimes called veil piercing, or piercing the corporate veil, where the person thinks that when they put the 100,000 in, that's all they risked. But in reality, they mixed their personal money with their business money. They let their entity expire. They didn't have insurance, and they were doing some kind of high risk activity. Under those circumstances, courts will sometimes say that your entity was a shell or a sham, and I'm going to allow this litigant to come through the entity and come to you personally. That means your personal assets are on the line. That means your family is potentially jeopardized, or the financial health of your family. So don't treat your business entity like a sham or a shell. Treat it like a real thing. It should have its own bank account. It should have its own existence. You should follow corporate formalities by having meetings, taking minutes, and you won't expose yourself to a veil piercing argument. I would also say that lots of businesses forget that you need to renew your entity status on a regular basis. So this link is to the Secretary of State's website. You can go to the website. It's to a page that allows you to search for your business, put the business name in under the active box checked. And if you see your business and it says it's active, great. All the information is up to date, great. But if you don't see it, check the box for inactive and search again. If you find your business in the inactive category, that's not a good thing, and it potentially eliminates some of that protection businesses will have to COVID-19 risk. You want to just put your business at risk. You don't want to put your personal assets at risk. And with that, I think that's
well, you've got, Matt, you've got one more slide, I think, here.
Oh, I didn't see that. Oh, this one is a minor one, limiting liability to the government. No. So this one is avoid government penalties by providing required notices, and then follow the executive orders. These executive orders have very large penalties in them, potentially. I don't think it's very likely they will be enforced on a broad scale, but there are possibilities that if you really don't follow them and you make a big you make a big deal out of not following them, you're going to draw some attention, and you can potentially put your business at risk that way. And I would say to avoid terminations that violate employee rights. Check with your payroll provider, your HR department, your attorney, to run by them the fact scenario you have before you terminate an employee's employment. And don't cut corners. That's the bottom line. This is a very day-to-day kind of situation. Continue to read and educate yourself, and I think it's just going to help your business in the long run.
Matt, that is excellent information. We do have a question from someone who said, what do you do for a plan if you are a home care provider? So you don't have a brick and mortar, you're going into other people's homes.
I would take a look at that industry guidance. And what you need to think about is every point of contact that you have with someone that you're obviously, a home service provider. I'm not sure if this means someone who's cleaning homes.
Cleaning or like daycare. We've got daycare providers, cleaning homes, home health care, things like that.
Home health care would fit within the healthcare category. So you'd be thinking about a lot of the same things that a healthcare provider would. With regard to preparedness plans, I would say go to that link in the industry page that I had in the slide relating to the preparedness plans. And then also look at the sample preparedness plan. There's a lot of helpful information in there that if you look at the industry that most closely resembles what you're doing, whether it's cleaning someone's home, whether it's going and providing home care as a personal care attendant or a nurse, those things are all different, obviously. But that guidance is very helpful on the Department of Labor and Industry's website.
Wonderful. Matt, that is great information. And like Matt said, we will make the PowerPoint as well as the webinar available to everyone so that you can look through that. And we've got Matt's information up here on the screen. Matt, thank you so much for joining us today for that great information. Oh, you know what? I think we might have one more question here before we go. We have someone who asked, a company that has 2 employees and 5 family members, do all the same rules apply?
Um, I'm not sure about the rules, but if you're talking about the rules in terms of the executive orders, yes, those would all apply across the board. I would say that the federal laws, typically the ADA, and you have a lot of different federal laws that apply to employees. The Americans with or the Age Discrimination and Employment Act, Title VII, which is your civil rights claims, and a lot of those laws do provide protections to employees of larger employers. They do not apply to a small company like the one you described. But there are equivalents in state law. The Minnesota Human Rights Act applies to small employers of one or more. So there you're going to be covered by very similar laws. It's just kind of dependent on which law you're covered by. And I would say they are very similar, and in practice, they're difficult to distinguish for most employers. They have a few nuances where you get a jury trial under one and you don't get a jury trial under another one. But for the most part, the laws that I've described and the things that I've talked about apply to small employers.
Okay, wonderful. Thank you. Thank you so much again, Matt, for this great information. Just to remind everyone, our next webinar will be next Wednesday, June 3rd. It is going to be with Glenn Starfield, who is a franchise owner of Express Employment and Professionals. And Glenn is going to be talking about staffing trends during our COVID pandemic here. And again, this webinar was provided in partnership with the Apple Valley, Burnsville, Hastings, Lakeville, and River Heights Chambers of Commerce. And again, this recording will be made available on all of our partner websites. Matt, thank you again so much. That was excellent information. You are a great instructor. If you ever leave law, you should become a teacher. You do a great job. So thank you. Thank you so much, and thank everyone. Have a great day. Thanks, Matt.
Thank you.
Bye-bye.